Section 18, Legal Implications for Homeowners. Don't default. Several days after helping Lisa understand the benefits and drawbacks of a short sale, Melissa received another call from her. "I've decided I want to move forward with a short sale," Lisa said, "but now I'm worried about the legal side of everything. Someone told me I could still owe money after the sale. Someone else mentioned taxes, and another person said bankruptcy. I don't know what's true anymore." Melissa smiled. "Those are important questions, and they're exactly the reason realtors need to know where their role begins and where it ends." That afternoon, Lisa met with Melissa and David once again. David began by saying, "One of the most important things realtors can do is educate clients about the issues they may encounter, while recognizing when it's time to involve an attorney, CPA, or other qualified professional. Our job isn't to give legal advice. Our job is to help clients recognize when legal issues exist." Lisa nodded. "So where do those legal issues usually begin?" "Most often," David replied, "they begin with the money that's still owed after the property is sold." He explained that many distressed homeowners have more than one loan secured by the property. In addition to the first mortgage, some homeowners have second mortgages, home equity lines of credit, HELOCs, or other junior liens. Because these junior liens are subordinate to the first mortgage, they are only paid after the first lien has been satisfied. If there is not enough money from the sale to pay everyone, the junior lien holder may receive little or nothing, creating additional legal and financial issues that must be resolved before the transaction can close. Melissa asked, "Is that why negotiations with second lien holders sometimes take so long?" "Exactly," David answered. Junior lien holders know they are in a weaker position than the first lender, but they also know they may have legal rights against the borrower. That's why they often negotiate separately before agreeing to release their lien. He explained that every lien against the property must be addressed before clear title can be transferred to the buyer. A successful short sale often requires cooperation not only from the primary lender, but also from every lien holder with a recorded interest in the property. Lisa then asked the question she had been most worried about. "Can I still owe money after the short sale closes?" David nodded. "Possibly." He explained that one of the most significant legal issues homeowners face is the possibility of a deficiency balance. A deficiency occurs when the amount received from the sale is less than the total amount owed on the loan. While some lenders agree to forgive the remaining balance, others may require the borrower to contribute funds or sign an unsecured promissory note before approving the short sale. For that reason, homeowners should carefully review every approval letter and never assume the remaining balance has automatically been forgiven. Melissa added, "That's why we always encourage our clients to have an attorney review the lender's approval letter before they sign it." David smiled. "Exactly. Realtors can explain the transaction, but we don't interpret legal documents or advise clients about their legal liability." Lisa remembered hearing something about Arizona's anti-deficiency laws. "I thought Arizona protected homeowners from deficiency judgments." David explained that Arizona does provide strong anti-deficiency protections under certain circumstances, particularly following qualifying trustee sales and judicial foreclosures involving certain owner-occupied residential properties. However, those protections do not automatically apply to short sales. If a homeowner voluntarily agrees to repay part of the remaining debt as part of the lender's approval, that agreement may create a new legal obligation. This is why understanding the lender's approval letter is so important before closing. Melissa then asked another question. "What about taxes? I've heard homeowners sometimes receive tax forms after a short sale." David explained that when a lender forgives mortgage debt, the Internal Revenue Service may consider the forgiven amount taxable income. Homeowners may receive a Form 1099-C reflecting the forgiven debt. However, several federal provisions, including the Mortgage Forgiveness Debt Relief Act, insolvency exclusions, and bankruptcy provisions, may provide relief in certain situations. Because tax laws frequently change, and every homeowner's financial circumstances are different, realtors should always recommend that clients consult a qualified tax professional before making decisions based upon potential tax consequences. Lisa looked relieved. "So the answer isn't always the same for everyone." "Exactly," David replied. "That's why realtors should avoid making promises about taxes or legal liability." Melissa then asked another question that many homeowners eventually face. "What if someone simply can't pay what's left after the short sale?" David explained that some homeowners eventually consult a bankruptcy attorney. Bankruptcy may discharge certain unsecured debts depending on the type of bankruptcy filed and the homeowner's individual financial circumstances. Filing bankruptcy also carries significant long-term financial and legal consequences, making professional legal advice essential before choosing that option. Realtors should recognize when bankruptcy becomes part of the conversation, but should never advise clients whether filing bankruptcy is appropriate. Before concluding the meeting, David reminded everyone that legal issues extend beyond the mortgage itself. Judgment liens, unpaid HOA assessments, IRS liens, HELOCs, and other encumbrances may all affect a homeowner's legal obligations during a short sale. Every property has its own title history, which is why realtors should encourage homeowners to work closely with the title company, their attorney, and other qualified professionals to fully understand any outstanding obligations before closing. As Lisa prepared to leave, she smiled. When I first started looking into a short sale, I thought it was simply selling my house for less than I owed. David smiled back. Most homeowners think that. But now you understand that a short sale involves much more than finding a buyer. It involves understanding liens, lender approval, possible legal liability, tax consequences, and knowing when to bring other professionals into the transaction. Melissa watched Lisa leave the office, feeling much more confident than when she had arrived. She realized that one of the realtor's greatest responsibilities is recognizing the legal issues that affect homeowners without crossing the line into practicing law. By educating clients, recommending appropriate professional advice, and helping coordinate the transaction, realtors help protect both the public and themselves throughout the short sale process. In the next section, we'll begin examining the realtor's role in preparing homeowners for a successful short sale by gathering the information and documentation lenders require before negotiations can begin. Online discussion. Discussion question 1. Why should realtors avoid giving legal or tax advice during a short sale transaction? Answer. Legal liability, tax consequences, bankruptcy, and deficiency judgments are outside the scope of a real estate license. Realtors should educate clients about these issues while recommending that they seek advice from qualified attorneys, CPAs, or other professionals. Discussion question 2. Why are second liens and HELOCs important during a short sale? Answer. Junior lien holders must often agree to release their liens before the sale can close. Because they are subordinate to the first mortgage, negotiations with these lenders can significantly affect whether the transaction is approved. Discussion question 3. Why should homeowners carefully review the lender's short sale approval letter? Answer. The approval letter may contain important legal terms, including deficiency waivers, promissory note requirements, or other financial obligations that survive closing. Homeowners should fully understand these terms before accepting them.